Today we're going to talk about closing the deal. The seller gets the goods to the buyer. What happens? In the best case scenario, the buyer is happy with the product. The payment has either already been made or will be made. The parties go on their way. This is the completion of performance, actual performance under a standard sales contract. Now, what happens when we're going to talk about today, the seller somehow fails to perform adequately. What remedies does the buyer have when there's been a failure by the seller under the contract? You might recall from your contracts course that courts take a fairly flexible approach to performance, asking questions like, well, is this a material breach, or has there been substantial compliance with the terms of the contract? The UCC, and I think this is actually unusual in that typically the UCC actually does take a more flexible approach often than the common law, but here the UCC takes a fairly strict approach. Goods are subject to the perfect tender rule. Under UCC 2601, if the goods or the delivery fail in any respect to conform to the contract, and that can be the description of the goods, you order something that's blue, you get something that's white, technical specifications about the goods, the time of delivery of the goods, or you deliver something late. These are all failures to conform with the contract, and in those cases, the buyer can reject the goods in whole or in part. So when a buyer gets defective goods or non-conforming goods, they have choices. The buyer could choose to say, I don't want any of these. They can say, I will make this work. I can use these. I accept them. Or they can say, maybe I will use some of these, but not all of them. Here, I'm rejecting this part of the non-conforming goods. Performance usually is completed by the seller when the seller tenders or delivers the goods to the buyer. And we're going to talk a little bit more about the distinction in assignment 20. After the buyer receives the goods, there are a number of points in time at which the buyer can identify and notify sellers of a non-conforming good. One thing your book emphasizes, and I think is worth holding in the back of our minds as we talk about buyer's remedies here, is that oftentimes buyers who are sophisticated and have fairly dynamic supply networks will have a supply chain management process in place where they vet their suppliers, the sellers, fairly closely and require that sellers comply with certain specifications. Often there'll be an initial period where a supplier is extensively vetted and the material that they're producing is vetted before it's actually used in a product. And so this is just one example. John Deere has this network. The big three are going to have supply chain networks. And so when there's been a breakdown in the goods that are being supplied, there are contractually built-in mechanisms for addressing those breakdowns. And so in a lot of industries, there are industry-specific methods and contractual agreements for dealing with non-conforming goods that aren't necessarily the UCC defaults. And there's actually been a lot of writing done about whether these defaults are helpful or not helpful, especially given that so many industries try to contract around them or contract more specific ways of addressing defaults. There are a lot of UCC provisions that we're talking about in this section. I'm going to try to condense the discussion of them a little bit, but what I think will be helpful in terms of framing as we go forward with this discussion is to think about if you're a buyer and you contract to buy a specific good, then that exact good is what you expect to receive. And if the seller doesn't send you that good or sends a defective or non-conforming good at the time called for under the contract, you as a buyer might feel rather pinched. It could be that you needed that good right away. And so the UCC is trying at least to give buyers the flexibility to feel comfortable saying, this is not conforming, or you didn't deliver this properly. I am going to reject these goods so that I can presumably get my money back. That's part of the default, but also so that I can go as a buyer and find goods that will actually meet my needs. Again, as your book points out, oftentimes there are sellers who contract around the default and say, we are limiting your remedies to repair and replacement for non-conforming goods. But the default really here is designed to give the buyer flexibility to get the goods that they need on a reasonable time frame. Perfect tender rule only applies to the one-off contracts, and so we'll talk a little bit about distinctions with installment contracts as we go forward. What does the buyer do with the goods when they receive them? All right, so there's a few steps along this chain. When the buyer initially receives the goods, they have an opportunity to inspect those goods. If after inspecting the goods, they decide that they're non-conforming, they can reject those goods. After a certain period of time goes forward, and we'll talk more about that in a minute, the buyer is said to have accepted the goods, at which point they can still notify the seller of defects, but it's not viewed as an initial rejection of goods. It's called a revocation of their acceptance of those goods. And whether we're talking about rejection or revocation, there are remedies available to the buyers because of the seller's breach. The seller's not delivering conforming goods, the seller's delivering ultimately defective goods. So, as I was saying, the buyer should inspect the goods. As your book points out, sometimes it's not worth the time for the buyer to inspect the goods initially. The buyer, if they discover something defective or non-conforming about the goods, can reject those goods if he seasonably notifies the seller. This is important, right? The buyer cannot sit on the goods for a period of time and then notify the seller that the goods were not conforming and that the buyer is rejecting them. And the baseline for the UCC is if the goods are non-conforming in any way, right, that the buyer has the right to reject them. Now again, your book talks about the real world. Many sellers will allow buyers to notify them that the goods are not conforming well past what might be considered a seasonable notification period. Well, why is that? Because if you want to have repeat business with your buyer, you're going to try what you can do within reason to keep your buyers happy. Right, so as I mentioned earlier, the UCC approach is actually stricter than the common law approach, except when we're talking about installment contracts, right? Contracts where the seller is sending a number of shipments to the buyer. In that case, the buyer is not supposed to be able to reject the installment unless the nonconformity substantially impairs the value of that particular installment, and they cannot reject the entire contract unless, and it's essentially a materiality standard, it's going back to the common law, unless the nonconformity substantially impairs the value of the whole contract. So what does this mean? What it means practically is that if there's something wrong with an installment, the buyer has the right to tell the seller that, and the seller has to cure. Right? So there's still the notice and cure, but the buyer can't then turn around and say, well, you sent me a bad batch, I don't trust you anymore, the whole contract is canceled. As I mentioned earlier, sellers do have the ability to contractually limit their remedies to things like repair and replacement, and this rejection right on the buyer's part is subject to notice and cure by the seller. And so under most circumstances, the seller will still have the opportunity to cure a defect. Right. If the buyer has been deemed to have accepted the goods, right, then the buyer can still revoke their acceptance, right? But they only can revoke if the nonconformity substantially impairs the value of the goods and seller didn't cure, or the buyer didn't discover that the goods were non-conforming because of seller's assurances, or because it would have been difficult under the circumstances to discover the non-conformity. And keep in mind that breach of warranty, those kinds of remedies are still available, even if we're in a situation where the buyer can no longer reject the goods, or possibly even that the buyer cannot revoke the goods. They could still bring a breach of warranty claim. All right. Now, what does acceptance mean? Because I've mentioned it a few times at this point. So UCC 2606 provides that acceptance can happen in a number of ways, but most of them boil down to this: the buyer keeps the goods. Okay? And we'll talk about this in more detail in our discussion problems. The buyer can affirmatively signal that he's keeping the goods. Payment for the goods is usually viewed as that kind of signal, although it's not conclusive. The buyer can fail to reject the goods after a reasonable period of inspection has passed, or the buyer can act in a way that is inconsistent with seller's ownership. For instance, the buyer could sell the goods to somebody else. All right. That would be indicating that the buyer now feels like the goods are their own, that they have the ownership rights to then sell them. Let's think about a scenario that might help us envision how this could play out. Let's say you're a restaurant owner and you own a restaurant called the Wolverine Den, and you primarily cater to fans of the University of Michigan. You order a set of mugs that you have requested come in bright yellow, maize. And instead you are sent a set of red mugs, crimson red, or perhaps even worse, scarlet red. So the seller has tended you non-conforming goods. Question is, what do you do at that point? Do you accept the non-conforming goods? Or what happens then? You don't accept them. Well, can you reject them? In part, that depends. If it's a single lot contract, a one-off, perfect tender rule. It doesn't conform if you order maize mugs and you get scarlet mugs. So subject to notice and cure, letting the seller know, you sent the wrong color, you need to make this right. It is subject to perfect tender rule. Let's say you decided maybe I can keep some of these red mugs because they'll be useful for, I don't know, cathartic destruction, a la the movie Office Space. That's also your right. If you want to keep some of them or reject all of them, those are options available to you. Let's say instead your restaurant goes through a lot of mugs, and so you have an ongoing installment contract with your seller that they will send you 100 mugs on a somewhat regular basis. In that case, the nonconformity must substantially impair the value of the contract and be incurable. So if, for instance, you're just so deeply offended to receive scarlet mugs as a Michigan fan, that's probably not going to be enough of a basis under an installment contract to substantially impair the value and be incurable. Let's say you sat on the decision. You perhaps didn't bother to open the box and inspect the mugs for several months until you needed them, and so the arguably seasonable period for rejection has passed and you are deemed to have accepted the mugs. Well, can you revoke your acceptance? And here, you can only revoke, the standard is frankly a little higher. Yes, you can revoke, but only if the nonconformity substantially impairs the value and the buyer only accepted assuming the defect would be cured or the nonconformity was not apparent on acceptance. So let's say not only are the mugs scarlet, but there's some defect with the mug. So it turns out that when you pick the mug up, it falls apart. Right? If that wasn't apparent on your acceptance, that might be the kind of ground, the kind of nonconformity that would substantially impair the value, essentially making them unusable, that would allow you as a buyer to revoke your acceptance. I'd like to save our 2 cases and 2 discussion problems for the class discussion tomorrow night, but just a couple of things to think about as you're looking over those cases again. For our North American Lighting versus Hopkins case, think about what is the buyer trying to do? Are they trying to reject the goods or revoke the goods? What are Hopkins' defenses? And they boil down to, I think, the notice period that should or should not be applied, and the court's inspection or consideration of impairment of value. So how do those questions play out? And then in the next case, the Cinco versus Metro North commuter Rail Company case, think about this doctrine that the case articulates of shaken faith. The idea that the buyer may be justified in rejecting goods outright if their faith is shaken in the goods themselves. And answer whether the court in this case allows Metro-North to use shaken faith as grounds for rejecting the goods. And also, how does the court look at the right of Cinco to attempt a cure for defective goods? So we'll talk about those two cases in a little bit more detail, as well as problem 18.1 and 18.2 for class on Thursday. Thanks so much.